Welcome to this interactive Needham Cable Channel program, co-sponsored by the Needham Area Immigration Justice Task Force and the League of Women Voters of Needham. I'm Karen Price, president of the Needham League. Our topic tonight is the Domestic Workers Bill of Rights law, what employers need to know. We have a panel of experts with us tonight to explain the background and implications of this Massachusetts law passed just last year. Tonight's program is geared toward the employers of domestic workers and their responsibilities. As with any new law, it is up to you to understand if the law pertains to you and what your responsibilities are. Our panel will explain the regulations and offer advice on how to comply. Our panel includes Lydia Edwards, Jonathan Miller, and Carrie Swope. I'll introduce each of them before they speak. Then we will have a question and answer period with our studio audience. Lydia Edwards is an attorney at Greater Boston Legal Services. She is part of the legal team that wrote and successfully lobbied for the Domestic Workers Bill of Rights, the law that brings us together here today. She is currently an Equal Justice Works Fellow and was recently named one of 40 City of Boston's Rising Star attorneys under 40 years of age. She also serves as the implementation coordinator for the Massachusetts Coalition for Domestic Workers. Welcome, Lydia.
Thank you. Hi, my name is Lydia Edwards, and I wanted to go into the background and explain how we got here before Jonathan goes through some of the more meat of the law, and then also as we explain some tax implications. So the coalition itself, has several members, some of whom are employers and many of whom are workers. We are consisting of the Boston Center for Independent Living, the Brazilian Women's Group, the Dominican Development Center, Mata Hari Eye of the Day, and the New England Jewish Labor Committee. Our legal counsel is the Greater Boston Legal Services. What got us today is a historic problem that has existed since the 1930s. For many people that are unaware, domestic workers and farm workers were excluded from the New Deal. And as a result, we've been playing catch up ever since. What that means is exclusion from federal and state laws, and that has resulted in women, predominantly women, working long hours with very few, if any, breaks. And also not getting paid overtime, any form of sick leave, any form of other benefits as well. To add to that, many of the workers have emotional ties to the families that's resulting in them not coming forward with a lot of the issues that they are concerned about. Further, adding to this issue is the fact that there are very few guidelines for employers and for families to follow on the state or national level. Adding then, of course, that many domestic workers work by themselves and are isolated through language or through cultural differences. Many of them are working, as you say, in the dark and are completely exploited and are completely ignored and are vulnerable to abuse. As a recent report noted, almost 90% of domestic workers have suffered from some form of harassment and have not come forward. Internationally, domestic workers and the industry itself is growing exponentially. If you were to actually collect all the domestic workers in the world and put them into one country, it would be the 10th largest employer in the world. Since 1990, the amount of people or women in domestic workers has increased by 20 million people in the industry. Many domestic workers are the primary breadwinners for their family, and of course, again, many of them are women, and in most cases, many of them are not getting benefits, are not being recognized, and do not have any form of organized labor. So in the United States, we actually had a survey in 2012 that really helped to highlight the disparity and the problems that we were facing. This survey called Home Economics was done by the National Domestic Workers Alliance, and the survey specifically highlighted some issues such as 85% of domestic workers were not getting overtime pay, 82% were not guaranteed paid sick days, 35% worked long hours without getting a break, and 25% of live-in workers, those are the live-in domestic workers, a family maybe has an extra room for her to stay in and she stays there 24 hours a day, were not able to get 5 hours or more of sleep. 35% of the live-in workers suffered from verbal and physical threats, and then again 91% did not bother to report the problems. So this is, again, a growing industry, as we saw worldwide, but also nationally. We expect an increase of 27 million in the next 20 years of people moving into this care industry. And we, at Massachusetts at least, decided that if we're going to grow in the light, and we're going to provide some guidelines for employers. So just very, very briefly, I'm going to talk about who's covered in the law and some very basic key points of the law. The domestic workers law is applied to any individual paid by a private household to perform domestic work. That includes housekeeping, childcare services, some elderly care, some assistance for people with disabilities. And any person who employs such an individual is considered an employer under this law. Who is excluded are casual babysitters, people who are employed, or domestic workers employed by staffing agencies that are licensed and registered with the state, personal care attendants who are paid by Mass Health or Medicaid. So some very basics of what the law does. It guarantees some basic labor rights and protections. For example, for every 7 calendar days worked, a person or a domestic worker is guaranteed 24 hours off. She's also guaranteed 48 hours off in a month. She gets meal and rest breaks as well, and it clarifies what exactly is working time. The law prohibits illegal charges for food, for lodging, for violation of privacy rights, for taking immigration documents, and it assures civil protections against labor trafficking. It also provides parental leave and discrimination protection for domestic workers. The law further provides for written notice and severance before termination for live-in workers only. It provides for information about the rights and responsibilities in a written agreement if you work more than 16 hours or more a week. You're also to be given all the information about your rights before you start your job. It provides for a right to ask about your job and how you're doing, and to have personnel records and to contest what's in those personnel records if you're given an evaluation. And it provides also enforcement mechanisms through the Attorney General's Office and the Massachusetts Commission Against Discrimination. So other public policy initiatives, and this is really speaking to the movement and our outreach to employers. We are developing, and when I say we, I'm referring to the Massachusetts Coalition for Domestic Workers, a multilingual outreach and training program for domestic workers and their employers, a Know Your Rights, model employment agreements, and a model notice of your rights. This is also provided for in the law for the Attorney General's Office to also implement. So with that, I will turn it over to Jonathan.
Thank you, Lydia. Our next panelist is Jonathan Miller, Chief of the Public Protection and Advocacy Bureau in the Office of Massachusetts Attorney General Maura Healey. Since joining the office in 2008, he also has served in the Civil Rights Division. His work has included enforcement of the state anti-discrimination laws and the protection of individual rights, including dozens of fair housing cases. He served as co-counsel with Attorney General Healey in Massachusetts' challenge to the Defense of Marriage Act and helped to secure passage of the Safe Access Law, which protects patients and staff entering and exiting reproductive health care facilities. Now we'll hear from Jonathan.
Thanks so much. And it's really a pleasure to be here and to join this conversation to talk about a new and very important law offering and securing very critical protections for domestic workers throughout Massachusetts. So I just wanted to spend a few minutes, I guess, sort of piggybacking on what Lydia discussed regarding sort of the requirements of the law. So some of this may be a little duplicative, but just to sort of underscore what the law covers and what requirements exist for employers and what rights exist for the workers. So who is a domestic worker? Those are employees who do domestic work in somebody else's household, such as housekeepers, nannies, other caretakers, but it doesn't include personal care attendants or casual babysitters. And the employer could be a family, somebody in a home, or it could be a business, for example, a business that has a cleaning service that sends people to lots of different homes. That would be the employer of the domestic worker in that particular context. So one of the most important things that the Domestic Worker Bill of Rights does is it makes it very clear to employers, to households, that all of the rights and protections that apply to workers apply to domestic workers, right? So things that are pretty straightforward, like minimum wage and overtime law, right? Those have always applied. This law doesn't actually change that, but it makes it very clear that they do, so that employers and households understand that those laws apply when you're employing a domestic worker in your household. So the minimum wage is actually going to be changing over the next couple of years. It's $9 an hour in Massachusetts right now. It'll go up to $10 an hour in 2016 and $11 an hour in 2017. So that's something for employers to be mindful of as they employ domestic workers in their household, that the minimum wage will continue to change over time. And the overtime law just simply requires that you pay time and a half for any hours worked in excess of 40 during a calendar week. So another new law that applies actually to all employees across Massachusetts, but is something that in particular we want to make sure that employers of domestic workers are aware of, is the Earned Sick Time law. And this is another law that our office has been very integrally involved in the implementation of over the last several months. So the Earned Sick Time law applies to all employees, and it enables employees to accrue and use up to 40 hours of job-protected sick leave every year. So it can be used for them to go to a medical appointment, to take a child or a spouse or a parent of a spouse to a medical appointment, and things of that nature. The benefit has to accrue at a rate of 1 hour for every 30 hours worked. And in most situations involving domestic workers, it may be unpaid. For employers of 11 people or more, so this going back to that cleaning company example where maybe you'd have more than 11 employees, then it's required to be paid. But for employers with fewer than 11 employees, it doesn't have to be paid. It can be. That's a benefit that the employer is allowed to provide, but it's not required under the law. So one critical thing among the many that the Domestic Worker Bill of Rights does is it requires employers to provide notice and information of rights before work begins. So this is a notice of rights under state and federal law for domestic workers that work 16 or more hours per week in the household, a written agreement that details job duties, the pay, the work schedule, time off, benefits, deductions, and other conditions of employment. And the idea is that it's going to be in writing ahead of time to make clear how the employment arrangement is supposed to work, so that there are no surprises after the fact. I think part of what's happening with this law is to clarify and underscore that this is an employer-employee relationship, and it needs to be treated like that. And so, if job responsibilities change, those need to be made clear, and that's the purpose of having things in writing. It's also required for employers who have an employee for 16 or more hours a week in their household, is that they provide timesheets. And again, this is critical to ensure that there's agreement in real time as the employment relationship goes on about how much time somebody worked. And that, if they say they worked 17 hours this week, both the employer and employee agree that that's how much they worked and that there's a record of it. The law also mandates certain requirements for rest periods if a domestic worker works 40 hours or more a week. And so what it requires is that every week there at least be 24 consecutive hours of no work, and that would be job-protected time off from work, and that at least once a month there's a 48-hour period in which no work is required. Workers may be are allowed to work during a scheduled day of rest, but that they have to voluntarily agree, and they have to agree to it in writing. And the days off can be paid or unpaid, and if they are paid, then they have to be considered vacation time and pay under the law. The Domestic Worker Bill of Rights also provides some very important safeguards in terms of privacy, and this is particularly critical in circumstances where you have a domestic worker living in the home, but they apply whether or not the employee is living in the home. So things like this prohibits monitoring and recording private spaces or activities, interfering with private communications, taking documents. Right? There are examples of cases where employers have taken passports or immigration documents that can be very threatening to a domestic worker. And so this is explicitly prohibited under the Domestic Worker Bill of Rights. There are also specific protections in place if it's a live-in domestic worker, because these are situations where I think workers are particularly vulnerable when they're terminated from employment because they may not have anywhere else to go or anywhere else to stay. So generally speaking, the employer ends the employment must provide written notice and 30 days lodging, or written notice and 2 weeks pay with at least some period of time, a reasonable period of time, like 24 hours, to find new lodging. If, however, termination is for cause, right, there was a reason, a specific reason why the relationship was ended, the employer has to provide written notice and a reasonable chance to find new lodging, at least 48 hours, unless the termination is based on a reasonable good faith belief that the domestic worker has caused harm to somebody in the household. So there are some additional protections that we wanted to highlight. This presentation doesn't go through every single protection that's outlined in the Domestic Worker Bill of Rights, but a few others to highlight. The written agreement between the employer and employee must state sort of the circumstances in which the employer may go into the living quarters, and also describe what would be considered termination for cause. It doesn't have to be every single reason, but it needs to be a good faith effort to describe the reasons for cause termination. And if the employer requires the employee to live somewhere, so whether that's in the household or another specific premises, the employer has to provide access to a phone or the internet services during the course of their employment. Domestic Worker Bill of Rights also makes abundantly clear that retaliation is prohibited under the law. So if a domestic worker is seeking to exercise their rights, such as complaining to the Attorney General's office about not being paid for wages, retaliation is prohibited. And that can include firing the employee, also reducing pay, giving the employee undesirable hours, reporting the employee to immigration officials, or threatening to do any of those things. The mere threat is retaliation as well. Just a quick note about enforcement. And before I say that, I'll say our office is a resource for employees, for employers. If people have questions, we're happy to take them from the public about their obligations, their duties under the law. But these rights and benefits to employees are enforceable. They can file complaints with our office. We review those complaints, we investigate them, and we bring enforcement actions when appropriate. Employees also have the right to proceed privately on their own with help from an attorney, like Lydia, to pursue a case in court. And they can, if they win, receive up to 3 times the wages owed plus costs and attorney's fees. So that's why it's critical that employers get this right. So this is just a list of resources that are available for employers on our website. We have a Fair Labor website. Our Domestic Worker Bill of Rights website includes sample documents like a sample agreement, a sample notice of that needs to be provided to the employee ahead of time, a number of other sample documents. We also have information related to the earned sick time law, and we also have a hotline that both employees or employers can call with questions or concerns at any time. And as I said before, we're here to be a resource and to be helpful both to households and to their employees as this new law goes into effect and people have questions about what it means for them. Thank you.
Great, thank you, John. Next we have Carrie Swope. She is a senior director at Care.com HomePay, the nation's leading household employment specialist. With a mission to help families handle all the tax and legal obligations that come with employing a caregiver in the home, Care.com HomePay is a go-to resource for thousands of placement agencies, accountants, financial advisors, and attorneys. We have asked Carrie to join us as an example of a business that can help employers of in-home workers with tax and legal requirements, in particular associated with this law. Welcome, Carrie.
Thank you so much for having me. So I'd like to cover, Lydia and John covered a lot of the details regarding the law and the legislation and the impact of that. I'd like to cover and spend a few minutes tonight the tax side of the impact of this new law and what that means for a family who employs a domestic worker, because we at Care.com HomePay know and help thousands of families deal with the law because we know that it's overbearing and quite complex. So the first is, and Lydia and John did a good job of explaining what a household employer is, but in the eyes of the IRS, that really means if you're employing a domestic worker and paying them more than $1,900 in a calendar year, the IRS does consider you to be a household employer, which means you must comply with the law. And as Lydia and John mentioned, a household employee includes anyone from a nanny or a housekeeper to a part-time babysitter, elder care providers, even a pet sitter could be considered a domestic worker. So what does that mean for a family? What does being a household employer mean, and what are the requirements behind that? Well, first off, you will have to obtain a tax ID with the IRS and the state government agencies, the Department of Labor and the Department of Revenue. After you obtain those IDs, you will file using those numbers with those government agencies on a quarterly basis, reporting the wages that you've paid to that worker every single pay period and what withholdings you have withheld from her paycheck, meaning taxes for Social Security and Medicare and federal and state income taxes in most cases. So you'll be tracking those wages throughout the calendar quarter, withholding taxes from your caregiver's wages throughout the quarter, and then you must file those on a quarterly basis, both with the IRS and with the state, and remit those tax dollars that you've been withholding. And then at the end of the year, you're going to file a form called a Schedule H with your personal income tax return to report that you've had this worker in your home, as well as provide a W-2 form to that worker so she can then report the wages earned on her personal income tax return. And then as the year progresses and you go through the year, you're also responsible as a family to respond to any notices received from the government, as well as comply with any new legislation, such as the Domestic Workers Bill of Rights, when those come about. So many families come to HomePay and ask, and have the common misperception that, is my worker really a domestic worker? I thought she was an independent contractor. And the IRS has consistently ruled that a domestic worker is indeed an an employee rather than an independent contractor, and that really hinges largely on three areas. One being who has control in the relationship. Oftentimes, the family is the one controlling who is doing the work in their home and how the work is being performed. And second, is the relationship an ongoing relationship? Meaning, is the worker going to continue to be working for you on an ongoing basis? And then lastly, the third factor in deciding that it's a household employer rather than an independent contractor is that worker largely economically dependent on being employed and the income received from this family? So those are some of the ways the IRS determines that this is an employee and not an independent contractor, but it's an often misperception that a lot of families, rightfully so, battle with. Now, if you are caught misclassifying your worker as an independent contractor, that comes with penalties and back taxes from the IRS and from the state. Recently, the Department of Labor and the IRS have teamed up to increase enforcement on independent contractor misclassification, and household employment industry is a target area for that. So one thing families don't consider as a part of the tax process and complying with the law is workers' compensation. Workers' compensation isn't a tax, it's an insurance policy similar to your homeowner's insurance policy. And what workers' compensation does is cover your employee if she's ever injured while working in your home. So it helps cover lost wages and medical expenses. And in the state of Massachusetts, a household employer is required to have a workers' compensation policy if that worker is working for you more than 16 hours in a week. And even in states that don't require workers' compensation, or even if your employee isn't working those more than 16 hours, meaning you aren't required, we always recommend to families at home pay that they go ahead and still get a workers' compensation policy, because they can still be held liable even though they don't meet those the hourly requirements if the employee is injured in their home. And we guide our clients. We have a resource that's solely for Care.com home pay families who can help those families get a workers' compensation policy through all risks. They provide Home Staff Protect program that we've partnered with them exclusively. So if a family has trouble. And then the last thing is tax breaks. So here's the good news. Despite all the tax complexities of being a household employer, there are benefits available to you if you are complying with the law that a lot of families aren't aware of, two being the flexible spending account and the child dependent care tax credit. So the flexible spending account allows a family to set aside up to $5,000 tax-free to put towards care expenses. Which saves them roughly anywhere from $2,000 to $2,300 in a year. And then the second is a child or dependent care tax credit that they will claim on their personal income tax return. And that allows them to itemize up to $3,000 per dependent and saves them roughly $600 to $1,200 a year. And if you have 2 or more children or 2 or more dependents, you can take advantage of both tax breaks. And a lot of families don't realize those tax breaks exist and that they can largely offset most, if not all, of the tax costs and care costs. That's household tax employment in a nutshell.
Okay, thank you very much, Carrie. Now we move to our audience questions. Our studio audience includes members of the community, all of whom have had experience with domestic workers. Some of the questions have been submitted on cards, and others will be asked by our studio audience. I'm going to ask the first question. It seems to me there's 2 types of domestic workers that one might have. Those that you're about to hire, where it might be a little easier to implement the law, and those who have maybe worked for you for 5 or 10 years. So I wondered if you could address some of the what you would recommend as the first steps in those 2 situations.
Sure, and we might split this up where I'll talk a little bit about the law. So just to be clear, so the law is effective as of April 1st of this year. So a lot of people are stuck in this kind of had a worker before or had an employee before, and now I have new obligations. And so the first thing that I would encourage everyone to do is to relax. and realize that the whole point of this law is to encourage communication and to ensure that we have boundaries clarified and that we have everything down in writing. Okay, it's actually supposed to help you. And so, and then the next thing I would tell them or encourage everyone to do is to actually go find free resources that are already available to you. We've said it before, but the Attorney General's website has several documents, several sample documents that you can use right away that are fill in the blank. They are meant to be used by non-lawyers so that you can go ahead and start that conversation. And I think whether you have somebody with 16 hours or more in your house, if you follow the sample written agreement, in many cases you're going to follow majority of this law if you actually discuss and write down and make sure it's clear. You should be obviously aware of certain other laws, such as what the minimum wage is, right? You're not going to agree to pay someone $3 an hour. And you should also know your overtime obligations, as well as we discussed the earned sick time. But honestly, it is designed to be user-friendly. So go and use the resources that are already available to you and make communication and taking time to talk with your domestic worker a part of your routine. Immediate, effective April 1st, and maybe just make April 1st every April 1st your day where you look at that contract. That would be my advice.
I'd like to follow on to Lydia's response. It's exactly what Care.com HomePay is helping families do is work through the exact same that exact scenario of I've had my caregiver for a year and a half. What do I need to do? And we're saying the exact same thing to our families that we're working with who are calling and asking the question, which is communicate with your employee. Make sure your employee knows her rights, because a lot of caregivers aren't familiar with this. So make sure your caregiver knows her rights and direct her to the resources where she can find more information. is step one, and then have the conversation about professionalizing the relationship if you hadn't already by creating and using one of the templates to create that employment agreement. And then revisit that on an annual basis. Make sure that you're having performance reviews at least on an annual basis, if not more frequently. There's a lot of great resources on care.com that offer advice on how to have a performance review. A lot of families haven't ever had to do that with or thought to do that with a caregiver working in their home, but that helps make the relationship more professional as well.
So would you suggest that arrange a time to meet, leave half an hour for that, an hour?
I would say it depends on how long that relationship has been.
Okay, and come prepared with some materials and knowledge of the law.
Absolutely. And some of the families we've been working with at care.com have had mutual conversations with their caregivers because they may potentially need to adjust their hours that they're working in order to comply.
Okay. So our studio audience, I see we have some questions, and we're going to hear from Susan. Yeah, go ahead.
I have a house cleaner who comes once a week, and sometimes she brings somebody else with her. How does the law apply to that situation?
So thanks for your question. Thanks for being here this evening. So it sounds like you're describing a situation where you have a house cleaner who probably is operating her own business and is employing other people directly through the business. So she would be the employer of domestic workers, and you would be paying her business directly for the cleaning service she's providing. But you're not her employer. That's a business-to-business relationship, like an independent contractor. And she, in that situation, would be the domestic. The employer of domestic workers, the employees of the company.
For our next question, we're going to go to Miles.
Well, actually, I have two questions. The first is, to what extent do these various provisions apply in the situation where the domestic worker is undocumented and has his or her own constraints, let's say, on what they can do and want to do? The other feeds off Susan's question. Suppose that you are hiring two sisters who in fact are twins, and are both of them your domestic workers? Do you make a separate deal with each one, or is the worker unit the two of them?
May I?
Yeah, sure. So the first question is about, you can take them in whatever order you like.
Both, actually.
Okay.
I work a lot with undocumented immigrants, and I am a twin. And so I feel compelled. So I wanted to, and feel free, obviously, but when dealing with a person who is undocumented, I mean, the law is very clear that you are not technically supposed to employ somebody unless you can demonstrate that they are able to work in the United States, and that's but it does happen. It happens very often in this industry that people do employ individuals who do not have work authorization. But this law was written, like most of the labor laws in Massachusetts, to apply to anyone who works. So if you have entered into an employment relationship, then your obligations begin as an employer, regardless of that person's immigration status. So your time to check and confirm whether they can work for you is probably in the first 72 hours, according to immigration laws. And if you have decided to employ that person, then you need to follow the law, all of the laws, including tax law. And then to the twin.
Well, can I just add something before we get to twins? And from our vantage as an entity that does enforcement, if we get a complaint from a worker, the immigration status is irrelevant to our analysis. And so if wages are owed, irrespective of immigration status, we'll investigate, and if it's necessary, enforce. So we'll work with everyone. We don't inquire about immigration status. We want to make sure that workers who are owed wages are paid.
And just a last point on that to follow on to Lydia and John was, you can absolutely be in compliance with tax law with employing an undocumented worker and be out of compliance with immigration law. It is possible. As Lydia mentioned, once you've made the choice to employ them, you can and should comply with tax laws. So you can still, all of the tax filings I referenced and the withholdings, you will still follow those, but we always recommend you check the employment eligibility at the beginning of the relationship and make sure that you're employing individuals who are able to work in the United States.
Great. We have another audience question from Lynn.
So I have an aide from my parents that works 50 hours a week, and I have no idea what my tax obligations are.
Just be sure before we go into the tax obligations that we're also, after 40 hours, right, she should be paid overtime, right? So as long as you're very clear, so we want to make sure we're getting our salary obligations first, right? And then moving into the tax obligations, right? So she is your employee, so she would, and I'll let you obviously finish with the W-2 and other tax forms that you need to file, but first be sure to be paying her overtime with the 50 hours. So that's 10 hours of overtime.
Yeah, absolutely. So yes, in addition to the overtime, making sure you're complying with the new legislation and providing her with 24 hours of rest. A written work agreement, as we discussed. From the tax side of things, the things I covered earlier, which are setting up a tax account with the IRS and the state, withholding taxes from her wages each pay period throughout the year, and then filing and remitting those throughout the year on a quarterly basis. And then at the end of the year, if you are the one employing the aide and claiming your parent as a dependent, you would be the one who's administering and managing this process and filing that Schedule H form on your personal income tax return and providing her with a W-2 to file. If you are not claiming your parent as a dependent, and despite the fact that you might be paying the wages, then your parent is the one in the eyes of the IRS who is employing the domestic worker and would be needing to file and administer the process, regardless of who's actually paying the wages.
And I think you heard earlier that one of the exceptions to the domestic workers law is personal care attendants, but that's a specific type of aid that's funded specifically through the Mass Health Program. So generally speaking, aids for parents, things like that, grandparents, are going to be covered by the domestic workers law. Just wanted to clarify that point.
All right. I see Susan has another question.
What about people who work less than 16 hours a week? Do they have any specific protections?
So Susan, that's a great question. So there are certain provisions of the Domestic Worker Bill of Rights that apply only to domestic workers that work 16 hours or more, but most of the protections apply to all domestic workers, irrespective of how many hours per week they work. And certainly things like minimum wage, overtime wouldn't apply because they're not likely to be working more than 40 hours, but at least minimum wage and other wage and hour laws like deductions for meals and lodging would apply to these workers as well. So there's only a few of the provisions that don't apply. Generally, all the wage and hour laws do apply, even to these domestic workers who do not work that many hours.
And just to add also, some of those other laws would be discrimination laws. So discrimination, right, so sexual harassment and racial discrimination, that's going to apply regardless, as long as she's your employee, as well as the notice of her rights and knowing what her rights would be, to be handed that when she starts. So you're going to make sure she knows her rights, and then no discrimination. And of course, you still have the tax obligations, right?
If you cross that $1,900 threshold, unfortunately, the tax liabilities come with it.
Okay. I see Eleanor has a question.
This question is addressed to John. What will happen if an employer violates the law with its various new provisions?
Eleanor, thanks for that question. Well, hopefully there won't be violations of the law, but we know that that will happen whether intentional or not. And so, certainly there are various things that workers can do to report violations of the law. They can come to our office, they can seek legal counsel, they can work with many of the community organizations that work directly with domestic workers who can point them in the right direction. If our office receives a complaint regarding a wage and hour violation or a violation of domestic worker bill of rights, that's something we're going to look into. Now, understanding that, we're not talking generally about sophisticated businesses, we're talking about households here. These are the types of things that we're going to look to have a conversation with the employer, with the household, and find out if sort of things can get squared away. But if they're, egregious problems, that might be where we take a, closer and harder look at the situation. So, as I said before earlier in the program, we're at this point, particularly given that this law, has only been in effect for a few months, looking to be a resource. But we also are, here to support the rights and the protections that are owed to workers.
Okay, I'm going to ask the next question. I have a question about au pairs. They sort of work for an agency. If you have an au pair in your house, are you then the employer?
That's an excellent question, and a lot of people do have questions about that relationship. So I have learned that there are some au pairs who retain an employee-employer relationship with their agencies, but I believe a majority of au pairs are actually placed in the homes. So majority of the agencies serve as a placement relationship, and they help with the visa, and they help with getting the worker and finding them and placing them in the home in the United States. So once that person is in your home in Massachusetts, and as long as they are caring for your children and they're doing domestic worker services, they are a domestic worker within our laws and would be considered an employee.
Okay.
I'll add to that because the tax side of employing an au pair is different than a domestic household employee or a traditional household employee. A family's obligations with the IRS in the state are very different. There are little to no tax obligations when you employ an au pair versus a household employee, and the reason being is because the au pair program here in the United States is largely viewed as a cultural exchange program instead of an employment program. So the tax obligations are very different for an au pair.
Okay. We're going to have one last audience question from Emily.
This all seems overwhelming. I am specifically concerned about the situation which is common now, care on elderly relative. And here you have a family member who has never dealt with any of this. Where can that person turn and get fast help? Because it's often an emergency situation. You don't want this elderly person careless, without care, and you can't do it. And I have a related question. The personal care attendant, what is the exact difference between that and someone who gives other elderly care? You said that it was a different agency that takes care of it. Is this a relative of an elderly person? How are they going to find out where to get help?
I'll take the lead on this one, just the first part of it. We at care.com help families in that exact situation. We help families and caregivers match and find each other, and we have a specific segment of our business focused on senior care to help situations just like that need care in the moment right away, who don't have time to vet multiple caregivers online. It's a concierge service that we offer. There's also placement agencies across the country that do the same thing that can immediately help put a worker in the home to care for your elderly loved one.
With regards to who is with a personal care attendant or an aide, the Domestic Worker Bill of Rights specifically cites to I think it's Chapter 140 of licensed and registered agencies. So if you are employed by a licensed or registered agency, as in you're directly employed by them and not just placed in the home, but you maintain your relationship and your paycheck is signed by that agency that's licensed or registered by the state, you would not be in this law. If your PCA, personal care attendant, is paid by Medicaid or Mass Health, that individual is not considered to be within this law for 99% of it, except for sexual harassment claims, which is something I wanted to bring up as well. If you choose to have someone doing the same exact type of work, but employ them directly in your home by yourself, that person and yourself as an employer, you're within the Domestic Worker Bill of Rights.
All right, well, that concludes our audience questions. On behalf of the Needham Area Immigration Justice Task Force and the Needham League of Women Voters, I would like to thank our great panelists for an informative presentation of this important new law. We hope that it will help the thousands of employers out there in Massachusetts about their rights and responsibilities. A special thanks goes to Dr. Eleanor Shore, a member of our studio audience, who dedicated her time and effort into developing this program from start to finish, soup to nuts, and to Mark Mandel and the Needham Channel. We have prepared, in conclusion, some key take-home messages. If you are an employer, the new law may apply to you. Know the law. Communication from the beginning in writing is key to a good working relationship. Establish boundaries and provide time to talk and resolve issues early on. Educate yourself through tax professionals, the Attorney General's website, and other sources. And don't wait to learn about the law until after it is enforced against you. And here are 3 websites from the 3 organizations represented here today. And to all of you, thank you for watching. Good night.